First case is 127221. Littell and Cherry Ryder, co-trustees of the Opal Littell Family Trust, Bonnie Beelman versus Oxy USA Incorporated, an appeal from Stevens County. Counsel?
Your Honor, on behalf of the appellants, David Seeley, Ryan Meyer, and Emily Arita, representing the movements.
And who will be arguing the case?
I will.
All right, and that is?
David Seeley.
Thank you. And for the appellee?
Your Honor, my name is Dan Littell. I'll be arguing the matter, and with me is Jonathan Slattery.
Okay, thank you. Do you wish to reserve time for rebuttal?
I would like to preserve 3 minutes, Your Honor.
You got it. Yeah, let's turn the phones off. Let's not have that in again, okay? Thank you. All right. Proceed, Counsel.
Good morning. May it please the court. I'm David Seeley. I represent the movements in this matter. And it's been my privilege to represent the class in the Opal Littell versus Oxy lawsuit. We're here today because of Merit's deliberate and undisclosed repudiation of the uniform limits on deductions from royalty payments for natural gas that were contained in the 2008 judgment in this class action.
Let me ask you a question about that, if I may.
Sure.
Isn't there some argument in the briefs that that's really not a judgment? That was just a consent, a contract that the parties entered into that time, and then that was approved by the district court? Is that some way not a judgment?
No, Your Honor, it is not, because it is attached to, incorporated in, referenced, and relied on and approved and reviewed by the court. In fact, it could not go into effect without the court's approval.
Why is that?
Because this is a class action under KSA 60-223. And there are thousands of absent class members who were not able to even attend the trial of this matter, who are affected by that settlement agreement because the court has ordered that it is valid and enforceable.
So the district court in its ruling has wiped all of that out, correct?
That's correct, Your
It's
Honor.
nothing.
Well, now the agreement is still there, but the judgment
Is unenforceable?
is unenforceable. That's correct.
That's rather shocking. Then do you no longer do the people no longer get gas payments?
No, because the leases remain in effect, Your Honor. They still get a monthly, they're still entitled under their lease
Under what
contract.
terms?
I'm sorry?
Under what terms?
Under terms that that are set forth in the lease as modified by the ruling in.
It's not according to the judgment? So they're not complying with the
Well,
judgment?
it is according to the judgment. It is applied in accordance with the judgment. And I guess you're right, that all that goes up in flames if the judgment is truly dormant.
Counsel, way back when Moby Dick was a minnow, I started my career. I practiced law in the country, and we did a lot of quiet title actions. And I quieted title all through Bourbon, Lynn, and Miami counties. Those judgments are well over 7 years old now. Are those now meaningless?
Not under our view, Your Honor. I believe under the district court's view that dormancy applies to every judgment and any kind of judgment, which is not what the statute says.
Pretty broad terms in the court's order.
Yet very broad, Your Honor, very broad.
So now all those ancients, why should we bother to record judgments then?
That's a fair question. I had the same question. Why are judgments filed? What is their effect? When does their effect end? It ends according to their terms. And in this case, the terms of the leases, the royalty payment obligation, and the modified payment prohibiting deductions for fuel and deductions in excess of 15 cents per MMBTU for gathering continue in effect.
Proceed with the rest of your.
Okay, thank you.
I'm still
All right.
working through that.
Your Honor, I wanted to thank Merit for drawing the court's attention to last week's decision from the 10th Circuit in our interlocutory appeal in the federal lawsuit, which holds that a plaintiff class can and should be certified in that case, and instructing the district court, the federal district court, to do so. This court may be interested to know that the 10th Circuit yesterday granted Merit's unopposed motion for an extension of time to file their motion for rehearing en banc, so the matter is still far from over. Just to be clear, we were forced to file that action in federal court after the district court in Stevens County ruled that the judgment was dormant and unextinguished and unenforceable. And so,
Well, quite frankly, that district court order is more profound than just this case, isn't it?
I think so, Your Honor. It sets a very dangerous precedent, and it's particularly dangerous to those of us who've practiced class action litigation, because no one has ever before suggested that a class action, a court-approved class action settlement is not binding as part of the judgment.
Let me ask you this. What's your concept of dormancy? Of judgment dormancy, because the statute speaks of that.
Yes, the statute does speak to it, Your Honor. Our concept of dormancy is that, as the statute says, if someone who has the ability to execute on a judgment fails to do so for a period of 5 years, or does not file a removal affidavit sworn under oath stating the amount that is due and owing, the specific amount, then that judgment can become dormant. But other dormants that are not susceptible to execution as defined in the statutes are not affected. They are outside the scope of the statutory scheme.
Is it, we use language that the judgment becomes dormant, but basically you're talking about enforcement of that judgment, aren't you?
Well, it is. Yes,
Your means of enforcing the judgment become dormant?
no,
If so, isn't that the same?
it is not the same, Your Honor.
Explain it.
Well, there are several reasons. One, because the trigger is the executability. If you don't have the ability to execute, and that's what the statute says, then the condition, the trigger, the condition precedent is not met, and the statute should not apply. And if the second consideration then becomes, how do you avoid your judgment becoming dormant? Well, you have to file a renewal affidavit, and that renewal affidavit requires that it be signed by the judgment creditor or their lawyer stating the remaining balance due and unpaid on the judgment.
Are you a creditor? You people you represent, are you a creditor?
Not yet, Your Honor, but we hope to be someday.
Okay.
We have unliquidated claims, we believe, against Merit for its de-implementation of the Littell settlement, if you will. It consciously decided to not honor that agreement.
Well, people break contracts all the time. The question I have is, how often do you get paid?
Monthly. The royalty owners get paid each and every month.
So is that a judgment every month?
Effectively going, well, it is if you treat the judgment here as being within the scope of the dormancy statute, then we would argue that as each recurring payment.
So you got 7 + 2 years
Right.
for each month.
Right.
Are there cases to that effect?
There are, Your Honor. And I believe we've cited the case of Marriage v. Strom and Wichita Federal Savings. The next point I'd like to make, Your Honor.
Is there a statute that says that, it basically refreshes every payment?
The statute doesn't say that, but the case laws under the dormancy statute have said that.
Mhm.
And the next,
Because it makes me think of, the Lilly Ledbetter Act. The whole point of that Equal Pay Act was so that she could bring suit after each bad pay, but that required statutory change. So that's why I'm asking.
well, what we would do, Your Honor, is what we did in the Littell case, which was bring a lawsuit, say you've underpaid our royalties. We get a judgment that makes us whole for the past and sets the framework for the future, prohibiting those type of deductions.
Mhm.
And that's what we would hope would happen here under the contempt power of the district court, not execution of a judgment, but enforcement of a judgment under the contempt power, which is not addressed in the dormancy statute. The other reason
And was this brought as a contempt act? Was that one of your claims?
we filed a motion to enforce, and the district court construed it
Okay,
as
yeah.
a motion for indirect contempt.
Mhm.
And the other piece of the next piece of the dormancy statute is reviver. And so with renewal, you can't get a renewal unless you have a specific amount and you have a judgment creditor, which we don't have. In fact, we can't even determine what amounts they owe us because they can't calculate them based on looking at the check stubs. I would encourage this court to look at least one of those check stubs, see if you can figure out what they're deducting for and how much they're deducting in MMBTUs, not in the MCFs that are shown on their check stubs. And the last piece of the next piece of the statutory scheme is the reviver provision, which is in 60-2404, which provides a dormant judgment can be revived only if the holder of the judgment files a motion for reviver and a conditional request for immediate execution in the event that the motion is granted. Then at the motion hearing, the court shall enter an order of reviver unless good cause to the contrary be shown. And thereupon execution shall issue forthwith. So here we have something that we think they owe us. It's not been liquidated. It's unknown. We can't figure it out from looking at the check stubs. And yet the court held that was eliminated by the dormancy provision, even though we had no ability to renew the judgment nor to revive the judgment because immediate execution is a part of that process. So here, an execution is only possible when an amount can be stated. The standard writ requires the conclusion of amount. No clerk is going to issue a writ of execution and no judge is going to sign it unless there's an amount stated there. You can't say, give me an order that says if merit violates the terms of the judgment in this case, then I win. You can't go, that's not execution. You can't enforce an injunction or a prohibition until it's been violated. That's the essential difference here. This judgment can certainly be enforced, and that's what we're attempting to do, but it cannot be executed upon. It cannot be executed upon. I'll stop there. And
I'm going to ask you a question because I didn't want to take up your time to ask you the question. So I'm doing it this way because it's just my lack of understanding, I guess, of class action lawsuits. So just as a education to me. So if once these people that are getting the royalty payments, say one person figures out that they're getting shorted, then do they have to go, it's only the class as a whole that can an individual?
well, an individual could do what we have done, which is file a motion.
But you did it as the
to enforce
class.
for the whole class.
Okay.
That's what we're attempting to do. But part of the problem with that is even if I could figure out on my client's royalty check what the numbers were, how do I do that for thousands of people in the class? How do I issue a writ of
To say how
execution
much is due
that says,
total.
You owe me X number of dollars when I can't figure that out for even one person.
But one person could come in to try to enforce.
They could if they knew.
If they could figure it out.
Yeah.
But okay. All right. Thank you.
Okay. Hold on just a sec till we get the time right. Okay.
Thank you, Your Honors. My name is Dan McClure. I'm here from Merit Energy. They're not actually a party to the judgment that they're seeking to enforce. Oxy is not a party to this matter, believe it or not, even though they're the party who's involved. This case is really the perfect case, I think, for the application of the dormant judgment statute. Here's a judge.
Explain that to me, please, because I'm trying to figure out what has become dormant.
Oh, well, they're trying to misuse the judgment and the motion to enforce the judgment. All the judgment really did was approve a class action settlement for something like $18 million. And because Rule 23223 requires a court in a class action to merely approve a settlement. That's all it did. They're trying to read the judgment as an injunction.
Now, don't be too quick, counsel.
Okay,
When I hear the term a court approving a settlement,
yes.
that sounds pretty close to being a judgment to me.
Well, it is a judgment. It is a
And
judgment.
what is the nature of that judgment?
Well, one of the things the judgment did was to dismiss all of the claims that were then pending, okay? And basically end the lawsuit. They're suggesting, though, that injunction, that judgment is somehow an injunction because there's a separate settlement agreement. It's an agreement between the parties.
Does
It
that-
is not incorporated into that judgment.
Does that judgment not affect, have an in rem effect?
No, I don't think so.
And explain that to me.
Well, because it just doesn't. It's an agreement between parties. It's a judgment as to parties. There's not any judgment as to real estate or oil and gas leases. Those are unaffected. Because you were asking earlier, well, doing away with the judgment means they can't enforce anything. No, they all have oil and gas leases in effect, unaffected by the judgment. Those leases require monthly royalty payments.
So the only in rem remedy any of these people would have in making this claim would be under the lease.
Well, under the lease, or in this case, to sue for breach of the settlement agreement. You got the judgment here, and then you've got the settlement agreement between the parties. They can sue for the breach of the settlement agreement, which provided in this case for some future limitations on the amount of deductions from royalties for gathering costs and the like. They are suing in federal court in the Ryder case for breach of the settlement agreement. And that's the proper way for them to proceed, not to try to enforce a judgment that did not incorporate that settlement and did not order that future provision become effective. They have a complete remedy through this action for breach of settlement agreement.
Can you stop for just a second? And this is addressed to both of you. It occurs to me that I would ask that both of you submit to the panel some status of what's going on in federal court. You mentioned it and you're aware, and I want to hear from both sides on
Sure. Well,
what the status of all of that is.
what I filed last week was a copy of this 10th Circuit opinion that in an interlocutory appeal approved and ordered a class action in the suit that they're bringing for breach of the settlement agreement, which is a breach of contract suit. They have an utter and complete relief available to them and to that class that they now have, the 10th Circuit has now ordered they can have. They don't need to try to get into this judgment issue in trying to apply the judgment as if the judgment incorporated the settlement agreement. All it did was, quote, approve it, okay? And then the parties are left to their own devices in the future. And that device that they are litigating, and appropriately so, is for breach of contract. Now, we don't think Merit, who bought the properties from Oxy, was subject to those future royalty provisions, but that goes to the merits. That's because of the way the agreement was read.
It's not really pertinent to.
No, it's not. That goes to the merits of whether Merit is really
But the
bound by
settlement agreement was not a judgment.
No,
It's just a settlement. So
that's right.
what's the dormancy issue?
Well, they're
Can't be
trying,
dormant if it's
they
not
are
a judgment.
they are trying to use the judgment as if it incorporates all of the settlement terms and makes the settlement agreement a judgment. I think it's a misuse of it, but when you look at what they're really trying to do here,
So your issue is they failed to state a claim,
well, that's part of it. That's part of it.
but is that what the court said?
Well, no, that's because the court hasn't
Court
reached.
said it was dormant.
The court hasn't reached that issue. They just said that it's dormant because the judgment was never, no action was taken for 15 years to do
But you're
it.
saying there was never a judgment.
Well, yeah, there was a judgment. The settlement agreement terms are not part of that
Right.
judgment. And that's why we think they've inappropriately used this vehicle. When you look at the motion to enforce they filed, they're trying to leap over all the issues that you would have to get to enforce a settlement agreement. File a complaint, have an answer, have discovery, have a class certification, have a trial on the merits, and then they get a judgment for breach of the settlement agreement.
Okay, so did you argue in, before the district court judge that this was a dormant judgment?
It was the Judge Ambrosia's initial sua sponte order that this was dormant when he saw how old it
And
was.
you agreed with that? I mean,
We didn't
did you?
disagree with it.
Well,
And
if you didn't disagree with it, then aren't you acquiescing in the fact that it was a judgment?
yeah, oh, there's no question a judgment was entered. That judgment has become dormant, particularly when you consider what they're trying to use the judgment for, to imply that it incorporates the body of the settlement agreement. And you look at their motion to enforce, all they're going to do is bring merit in a single hearing, to enforce the settlement agreement. I'm sorry, to enforce the judgment. They're going to in a single hearing and say, you're liable and there should be an accounting and you should pay money. And at volume 1, page 97, you can see what they asked for in the motion to enforce. At the conclusion, enter judgment in favor of the class against merit, including all amounts determined to be due and owing. So they want to use, somehow bootstrap this judgment that was entered in 2008 into a judgment that they can enforce by simply a motion to enforce.
Okay,
If that's what they're trying to do, then they should be also bound by the dormancy statute. If that's how they're trying to use the statute, if they're trying to use this judgment as
but
basically
it
a
sounds
money
like you're
judgment.
arguing two
I'm sorry?
conflicting things.
Well, they're trying to, I'm saying this is what they're trying to do. If they're trying to do this, then they should be barred by a dormancy
Okay,
statute.
so I'm the district judge
Yes.
and I enter a judgment that approves the settlement agreement. The only way, there's no way to enforce that judgment is what you're saying. The only thing would be a breach of the settlement agreement?
Well, if the judgment had incorporated the whole embodiment, if it had been a consent decree, like a divorce consent decree, where everything agreed to by the parties becomes the judgment of the court, then they can enforce that,
Well, the court didn't dismiss the case.
which.
I mean,
Court?
the trial court, originally, it didn't dismiss the case, it made a finding in the case.
Well,
right?
the original judgment actually dismissed the claims that had been brought in 1998 against Oxy.
So it dismissed the claims because of the settlement agreement. So that was the deal. Okay.
That was
yeah,
basically it.
Okay.
But the problem is you're bound, and
I
all
get
of
what
us are
you're saying.
bound by the statute. And the dormancy statute by its own terms says except for certain specific exceptions.
So
Yeah.
are you saying, it seems to me that there's language in the district court's opinion that says all judgments expire after 7 years if you don't have an execution on them. Is that correct?
No, that's not correct. It cited the statute as saying, it says any judgments, but all this court said, Judge Ambrosia, was that in this case, on these facts,
Well, the language was pretty broad. It says, all judgments.
well, he was quoting the statute, which says any judgments, except for the ones that are, it starts off with, except for those accepted in subsection B,
So if I
Any
get a
judgment.
title order from a judge, it expires in 7 years because I
You don't
don't
have
have an
to,
execution on it?
I don't know. I don't think you would have to reach that issue because this is not a quiet title suit. There's no quiet title suit in which somebody is coming in and asking for $10 million,
We have to deal with the language of that order.
right?
And if we approve that, aren't we saying then, unless you get an execution on a judgment, it's gonna expire in 5 years or 2 years after that, after it's dormant, it's done. I mean, that's the language that you're having to defend, isn't it?
No, I don't view the district court's language or its order, its findings of fact as saying that every conceivable judgment in the world, including quiet title actions or deck actions, are barred. He is saying that in an action like this, where you have an approval of a class settlement and where the plaintiffs are seeking essentially money, a money collection from the defendant, that kind of an action is the classic kind barred by the Dormant Judgment Act.
We have cases where people are ordered to pay money
Yes.
periodically. And the cases also say that every month that 7-year period is extended,
When, yes, yes.
but it comes due. So how is that any different here when these payments are due under the contract that you have under the leases every month?
There's
So
a,
why isn't it 7 years after each particular month's payment?
well, because there's a huge difference between those cases and this case.
Explain it to me.
Well, in those cases, you have divorce cases that order somebody to pay monthly alimony
Well, you've
or
agreed to it and the court has approved
it's
and so you got an order, right?
well, no, you don't have an order in the judgment ordering compliance with that statute, with that agreement. All you have is now a private or separate settlement agreement, and that can be enforced by a breach of contract action.
Law says a judge has to approve these particular class action judgments, correct?
Yes, it's fair and equitable.
Mhm.
But that approval is not the same as a consent decree. We got a lot of cases in here throughout America, federal and state, that say just because you approve a class action settlement doesn't mean that all of the terms of the settlement have the effect of an order, a court order like a consent decree, forcing and allowing for a motion to enforce under those circumstances. Huge difference between a divorce decree that orders somebody to pay alimony for 20 years each month and a mere approval of a settlement. Their remedy now is to sue for breach of the settlement agreement when, well, it's actually the leases that give you the right to get paid every month. The settlement agreement here limits the scope of the deductions, they claim, and that's what they can and are suing for in the other case.
This has to have come up before. I mean, class actions end in settlement agreement. I mean, that's
Yes.
how they end.
Yes.
Generally.
Yes.
So are there cases out there that specifically say you can't file an action to enforce that settlement agreement it has to be a contract issue that you violated the settlement agreement? I mean, how have there been claims that have been made like the appellant makes here that have been accepted? And what's your best case that they're not?
Every case I'm aware of where somebody has a class action settlement that has some future term, the mechanism to enforce is to sue for breach of the settlement agreement, all right?
That may be a mechanism, but are there cases out there where the mechanism that was used here was used and supported in Kansas?
I don't think anybody in the United States has ever tried to do what they're trying to do,
Okay.
which is to merely take an approval of a settlement and treat that as an effective injunction.
Okay, so you
Body-
say there are no published cases out there that you are aware of?
I don't think so.
In Kansas, and what about elsewhere?
I don't think so,
Okay.
because nobody's ever tried to do what they tried to do.
Okay, all right.
Now, I just want to touch briefly on his suggestion that, we don't know how much is owed and all that stuff. Merit started paying royalties in 2014. They waited 9 years to bring this action. Their own lawyer at the time, who's his partner, Mr. Seeley's partner, Mr. Stuckey, in support of this particular motion, filed an affidavit in which he said, you can, right on the face of the checks, you can see what the deductions are. In fact, you can see right on the face of the checks. You can readily see it, what it is. And he said that it was perfectly clear. That's at the record, volume 1, page 230. They said, well, we don't know about MMBTUs and all you reported was MCF. He said directly that it's generally a close 1-to-1 correlation. So calculating deductions per MCF provides a close estimate of the deductions.
So there's not a discoverability issue, you're saying? They could have seen it all along.
Oh, they unquestionably, that's what their lawyer in 2023 determined. Had he looked at it in 2014, or had had Ms. Ryder, who was the class rep after all in the first settlement, simply looked at it, studied it. It doesn't take it's really fairly much
Mr.
arithmetic.
Seeley, I'm sorry, but you're going to have to stop it with the
So-
facial expressions and laughing and not appropriate.
Mr. Stuckey's affidavit demonstrates how easy and simple it was to see on the face of the deal in 2014 that there was clearly amounts at 3 to 9 times in the month of July to 2014, yet they waited 9 years to proceed. Even if there was some tolling, the statute doesn't allow tolling here anyway in this, a discovery rule tolling. It's not in the statute. They could have easily brought a renewal affidavit, a motion for reviver, and done anything else, but 9 more years passed. So even if there was some tolling of any sort, they've had 9 years, and they waited 9 years to bring
So
any
they'd
act.
be outside of a statute of limitations to bring an enforcement of the
Well,
settlement agreement action, according to that theory, right?
In the other case, in the Ryder case,
Mhm.
they conceded that 3 years of limitations passed, but to 2017, but not after 2017. And so that's what they've already conceded in the other case.
The other case.
But in my view, this case clearly falls within the statute. It's not within Judge Ambrosier's discretion to change the statute, to create exceptions for injunctions or for any other provision. The legislature chose not to create an exception for this kind of a matter. And
Counsel, you need to sum up.
I'm sorry.
All right,
Concluded.
you done?
Yes,
Okay, thank you.
thank you.
3 minutes, you've got it.
Thank you, Your Honor. First, I just want to clarify that we are pursuing this matter as an action for enforcement because we believe there is no statute of limitations on a motion to enforce a judgment that has continuing effect. Second, I want to just dispute counsel's suggestion that Judge Smith, Tom Smith, may rest in peace, just rubber stamped this thing. That's not true. He took his responsibilities under 60-2223 very seriously. He reviewed it carefully. He discussed it. It was discussed.
Well, that's not an issue though. It's
During the
whether he
settlement.
reviewed it. We have he said it was fair and everybody seems to agree it was fair and equitable.
Thank
That's
you,
not
Your
an
Honor.
issue.
Next, I'd like to just say there is a discoverability issue here.
Mhm.
And Mr. Stuckey's affidavit, Mr. Stuckey has 50 years of experience litigating against oil and gas companies in the Hugoton field in Kansas. And based on that experience, he was able to make an estimate only, of what he thought the deductions being taken were. But an ordinary farmer, rancher, royalty owner doesn't know that, and Merit doesn't provide the BTU content of its gas in a conversion factor so that you can convert MCFs to MMBTUs and determine whether they're violating the 15 cent per
How did the district
MMBTU.
court address that issue?
It did not.
Did it need to?
I think it did to the extent that it certainly relates to the tolling issue. If you can't determine it, you can't execute, you can't enforce. If you can't determine it, you can't put an amount on a writ of execution.
Counsel, your opponent says you are doing something unusual here, totally unique. Nobody in the United States has ever filed a lawsuit such as this.
No, Your Honor, that's incorrect. There have been motions to enforce settlement agreements filed in many states, and I'm sure in Kansas, we've not had to do this before because everyone's lived up to their obligations after the settlement. But in some instances, there have been irregularities and motions to enforce the settlement, motions to enforce the judgment have been filed to enforce the terms.
Are there reported cases and do you cite any of them in your brief?
I can't cite any now, Your Honor. I'm sorry.
And that wasn't addressed in your brief as far as you know?
No, Your Honor.
Okay, thank you.
Any other questions?
No, I don't have any.
Thank you, counsel.
Your Honor, I just like to close by saying that we believe this court should follow the example set by the 10th Circuit. Just as that court rejected Merit's attempt to deprive the class of the remedy available to them under Rule 23 and under the court's contempt power to enforce the judgment, so should this court refuse to strip them of the right to enforce the terms of the judgment that Merit has deliberately violated. The rulings of the district court should be reversed, case should be remanded as more fully set forth in our opening brief. Thank you, Your Honor.
Thank you very much.
Counsel. Very interesting case. We'll take the matter under advisement and issue a written decision when it's done.
You'll get it when you get it.
Like those submissions regarding the status.
Oh, 10 days or so. Both, you can do it simultaneously.
Is there something more that we need besides the Tenth Circuit opinion? You'll just need to tell us that you filed there was some sort of extension of,
Just something in a status of what's going on in federal.
Okay.
Something jointly filed as opposed.
Well, it doesn't matter.
Yeah,
We'd be happy to
We could
work
do it
with
jointly. That would be
We can do a
fine.
joint search.
Yeah, it just keeps us advised of what's going on. I'm not sure that
impacts.
it affects us, but we'd like to know what's going on.
We'll get together and file something jointly.
All right.
Thank you, Your Honor.
Very
Thank
good,
you.
thank you.